Hi, good afternoon, everybody. Welcome to Law 2022 Online, Immigration Law, Shape the Debate, which is sponsored by Trinity College London with me, Deborah Morgan, Adam Pipe and Priya Solanki. In this live session, you can put your questions to Adam and Priya and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you are watching a replay, the live chat function is disabled, but you may contact the solicitors group for further information. A recording of today's live session will be sent out by email within a few days, so please keep an eye out for it. So, introductions. I'm Deborah Morgan. And the CELT account coordinator for Trinity's secure English language testing. During lockdown, we transitioned into the new government contract to provide CELT for the UKVI in the UK, and we are proud to be market leaders in providing this service. We take pride in looking after your clients in our centres and have a great depth of understanding of the stressful journey and high stakes involved in the visa process to whatever route they are taking to remain in the UK. We acknowledge and have compassion for all your customers are not the same and have different needs in their journey, and we work hard and are experienced in offering a tailored service to your clients as they take their CELT with us. More information on Trinity College London can be found on the online exhibition at thesolicitorsgroup.co.uk. So now to introduce you to Adam Pipe. Adam has been a barrister since 1999 and practices in all areas of immigration and asylum law. For many years, Adam has been ranked by Chambers and Partners as one of the leading immigration law specialists in the Midlands. In 2016, Adam was part of the Bar Standards Board Public and Licensed Access Review Task Completion Group. Adam was shortlisted for Barrister of the Year at the Birmingham Law Society Legal Awards in 2013, 2014 and 2019. As part of Law 2022 Online, Adam Pipe's session include Immigration, Asylum and Human Rights Update, Mind the Gap, ILR, Long Residence and Overstaying. So to introduce you to Priya Solanki. Priya was called to the bar in 2008. She practices from One Pump Court Chambers, London. She is a busy and experienced specialist in immigration, asylum, human rights and nationality law. For many years, she has been cited as a leading junior in immigration, including business immigration, in the Legal 500. The directory states she is tactically astute, good under pressure, and very persuasive in court. Priya has a particular interest in and experience of cases involving gender violence, modern slavery, mental health issues, vulnerable clients, and deportation. Priya's sessions for Law 2022 Online include, sorry, Priya.
That's okay. So it is, my sessions are on leave to remain based on qualifying children, and also a modern slavery and trafficking update.
Right, okay, got that, thank you. So to kick off, we'll start addressing some of your pre-submitted questions we have been receiving from you. So, Priya, can you explain the recent Court of Appeal decision in EOG and ANOR versus Secretary of State for the Home Department 2022, EWCA CIV 307?
Sure. So in my session, I spoke about the decisions from the High Court in the cases of EOG and KTT. So EOG was a potential victim of trafficking who had a positive reasonable grounds decision, which means that it was suspected that they were a victim of trafficking. And what was being argued by EOG is that she should be given discretionary leave to remain while she was awaiting the conclusive grounds decision. And there was a significant delay in that conclusive grounds decision being made. And the challenge was successful in the High Court. It was considered that somebody in that situation should potentially be given discretionary leave to remain, and that the policy guidance was lacking and contrary to the Trafficking Convention. KTT was an individual who had a positive conclusive grounds decision and also a simultaneous asylum claim. And what was being said by KTT was that because I have been positively determined to be a victim of modern slavery, whilst my asylum claim is outstanding, I should be given discretionary leave. And again, that was a challenge that succeeded in the High Court. Again, it was said that the Secretary of State's policy guidance was lacking. Now, the Secretary of State appealed those decisions to the Court of Appeal, and unfortunately, they were successful in their appeal in EOG's case. So somebody who has a positive reasonable grounds decision, but doesn't have a conclusive grounds decision, what was said in that situation was that they should not be removed. That's what the convention says, but that's different from a positive obligation to give them leave to remain. However, somebody who has a positive conclusive grounds decision like KTT and also has an outstanding asylum claim, it was said that in those circumstances, the wording of the Trafficking Convention was such that they should be given leave to remain. So the Court of Appeal upheld the decision of the High Court for KTT. However, today I've received notice in a couple of cases that they have unfortunately appealed KTT to the Supreme Court, and so they're seeking stays in cases that are outstanding before the upper tribunal and the High Court on these issues. Adam, can you think of anything to add to that?
Do you think if the Home Office have appealed KTT was obviously a positive decision with the huge delays waiting for conclusive grounds decisions. Do you know if they're appealing, the appellants are appealing EOG to the Supreme Court?
I don't know that yet. I could make inquiries though.
And you wonder if there are certain circumstances where even those with reasonable grounds decision could, maybe with his children involved or something, make some sort of discretionary application for leave to remain while they wait for the conclusive grounds decision.
Yes, absolutely. And I do think there'll be very strong arguments against them seeking a stay, because who knows how long any appeal to the Supreme Court will take. And of course, these individuals have often been waiting for such a long time anyway. And the truth is, them giving discretionary leave could be for quite a short period of time whilst the asylum claim is ongoing. And that is far better than leaving somebody without absolutely anything for even longer.
One way that links to my session is the whole thing about care workers being added to the shortage occupation list, that then if those waiting for an asylum decision following KTT are given a period of leave, you know, you've now got opened up the you know, shortage to the shortage occupation care work. So that is a positive thing if they do get permission to work.
Absolutely. Yes, Adam.
Okay. So we have one for Adam now. What is the current position with Zambrano cases?
Good question, I think. I'd like to know, and actually, if anybody's got any developments in their ongoing Zambrano applications, do post them in the chat, because it'll be interesting to see experience. So, as you know, the Akinsanya case succeeded at first instance. Similar. It's the same judge actually in EOG, Mr. Justice Mostyn. He's obviously on a roll, and yes. that got appealed, the Akinsanya case, to the Court of Appeal. The Secretary of State's appeal failed, but actually, as I described it in my session, it was a bit of a score draw, because the Secretary of State failed in terms of their interpretation of the EEA regulations, that the EEA regulations only exclude somebody who has indefinite leave to remain. And a person with a Zambrano right to reside in Appendix EU, it links back to the definition in the EEA regulations. So the Secretary of State lost on that aspect. But ultimately, the Court of Appeal found on the first point that their interpretation of a Zambrano right to reside was correct. And it is a sort of last resort thing, and somebody without leave to remain under domestic provisions. So the Secretary of State now is back reconsidering, and the sort of consent order that was put in place by Mr. Justice Mostyn has been modified, and the Secretary of State is reconsidering her position. So it'll be interesting to see what she does and whether she continues with this restrictive approach to a Zambrano right to reside, which actually does now, we know, properly reflect EU law. I've seen some emails from solicitors saying they've been invited to withdraw an application where they've got a simultaneous application under Appendix FM and Appendix EU. I think it's a bit early to do that while they're reconsidering Appendix EU, and we don't know what they're going to say in the meantime. But at the moment, I think cases are on hold, and I can see Kate's put in the chat, actually, the cases are being put on hold. They're being notified by clients by email or letters. However, biometric appointments are being booked to my clients by my clients on invitation by letter. So yeah, that reflects what Kate has said in the chat. So thanks for that, Kate. But that's the current position. Even though the Secretary of State lost in Zambrano, ultimately their interpretation of what a Zambrano right to reside was accepted as correct, and we wait to see what they'll do. Just one thing to finish on that is paragraph 57 of the judgment. Lord Justice Underhill talked about Zambrano always waiting in the wings, and if somebody lost their domestic right, they'd never be made illegal because that Zambrano right would kick in. So it'd be interesting to see how that plays out in the future.
Okay, so we have one from the audience now. It might be a very obvious question, but I would invite your views on how, as expert witnesses, we shall have access to providing assessment services to those that may be relocated to Rwanda. And that's from Ali Tyrrell.
Okay. I mean, I was reading something on this yesterday, and I think that what's been said about it is that actually there won't be legal obligations from the UK once that individual is sent to Rwanda. Rwanda takes on the responsibility for then processing that individual's asylum claim. So, I mean, considering that, I don't imagine that instructions will be coming from the UK, basically. Adam?
No, I think that's right. Well, I've tried to avoid reading too much into this because it just drives you mad.
Very depressing.
just makes you angry. In terms, I think these are the claims that are deemed inadmissible under the new bill that will become the new act. So these are the inadmissible claims. I suppose, Ali, I know, is an independent social worker. If there are challenges that require somebody to be assessed, challenges can still be made potentially if there was some sort of judicial review about a decision and somebody was already in Rwanda and an assessment would be done, I suppose, has been done during the pandemic. Maybe there'll be scope for video link assessments, but I think Priya is right that ultimately, you know, there won't be that claim in the United Kingdom. But I suspect if there was a challenge to some admissibility issue, maybe that would have to be done by video link. I suppose what we're saying is pretty much speculation.
I think so, yeah.
There are huge issues around this policy.
So one for Priya here. One of my clients has a negative conclusive grounds decision, which is over 12 months old. Her claim was refused owing to credibility issues. Her asylum claim is still outstanding. How do I seek reconsideration of her conclusive grounds decision, and what evidence would you suggest?
Okay, so the Home Office policy guidance is actually quite useful. This is their modern slavery guidance in setting out how an individual can seek reconsideration of both the reasonable grounds decision and a conclusive grounds decision. Now, generally speaking, they refuse on credibility grounds. It's quite difficult to advise on the sorts of evidence that you should submit because it's all, of course, very fact specific, but I'll try to give some examples and I'll try to explain the process to you. So there's no time limit on seeking a reconsideration. It can be done at any stage. Ultimately, what you are doing is either showing to them that the decision that they made is not in accordance with their own policy guidance on credibility, for example, or it's not in accordance with the authorities. And there's been some really useful authorities actually on how to approach credibility for victims of modern slavery and trafficking. So you would be looking at that decision and thinking how you can challenge specific things that are said in there. And it might be that there was no witness statement submitted from the applicant before the claim was decided, and that you are able to address a lot of what is said through, in fact, the client's own evidence. It may well be that you think about getting a trafficking expert report or a country expert report if there are things that are said about the claim not being consistent with objective evidence. It may well be that there's medical evidence that your client has since obtained, for example, for the purposes of their asylum claim, that might go quite far in explaining why there have been inconsistencies. They may have, for example, PTSD or depression that needs to be taken into account and wasn't taken into account because the competent authority didn't have access to that sort of evidence. You should be submitting a reconsideration request, ideally through a first responder. So that would be through somebody like Salvation Army. However, what their guidance says is that they won't reject a reconsideration request if it isn't submitted through a first responder or a support provider. So a solicitor effectively can submit it, and they shouldn't reject it because it's not been submitted by the right category of person. And they have to have a look at what has been sent in, even if it's simply to say, you know, we don't think that it's enough to reconsider. But if you wanted more detailed information on exactly what to submit, I'd suggest that you contacted me or Adam with the actual decision, and we'd be able to properly advise you on what might be useful. Adam, can you think of anything to add to that?
Just two things came to mind. I suppose the policy for reconsiderations is where there's new evidence. If you haven't got any new evidence but are still troubled by the assessment of credibility, I suppose it would have to be a pre-action letter and judicial review. But if you've got new evidence, you've got that alternative remedy of a reconsideration. And Priya, you mentioned helpful case law. I was particularly struck, obviously it's a decision of a deputy High Court judge, but that case TVN from David Locke, Queen's Counsel.
Yes, that's a great decision.
Really helpful stuff on credibility. And I've used it in perhaps asylum claims where there's a traffic in the background. So yeah, have a look at that, certainly, because that's some really helpful stuff in there. So those are the only two things that came to mind.
Okay, thank you. So there seems to be an inclination by the FTT IAC for appellants to justify why they want a face-to-face appeal hearings. Do you think that this is a right approach in reference to fair hearing, and has remote hearing of appeals now the norm?
I can take that. I think actually it's the opposite now. As I understand, the new guidance from the president, the judge, or the Lord Chief, it may even be, is that face-to-face hearings are now the norm, and you have to show why you should have a remote hearing. So it's now flipped. What I will say is I see variation with the different tribunal hearing centres around the UK. So I'm based in Birmingham, and Birmingham have got a very much, it's face-to-face, unless you've got a particular request why it should be a remote hearing. Certainly doing cases in London, particularly Taylor House, still seem to be very flexible and doing a lot of remote hearings or hybrid hearings. Hybrid hearing sometimes problematic when you've got some parties in court and some parties on video. So I think the direction of travel certainly is back to face-to-face hearings, and actually you'll probably be asked to justify why you want a remote hearing as opposed to face-to-face. I don't know if that's your experience, Priya, before the tribunal at the moment.
Absolutely, yes. I mean, in Birmingham, you have, I mean, my experience in Birmingham is they just won't list it remotely, actually, even if you've got a pretty good justification. So, for example, actually, tomorrow I've got a case there where the client is disabled, and even in that situation, they've said that they want it face to face, or that it can be moved to a hearing centre that's closer to him to be face to face. However, Adam is right that there is a significant difference between hearing centres, and I would say that in London that around 50% is still being listed remotely or hybrid, but it may well be that does change. I also think that some of it is a preference by the particular judge that might be dealing with it. So, for example, I've certainly had an upper tribunal judge in Manchester who has expressed a preference for having remote hearings, and I've noticed that everything that I've had in front of him has been listed remotely. But I don't know if in the FTT they have that much say over it. Actually, it's probably just all done by listings.
Okay, so I have a question here. I was wondering how to go about fee waiver requests for entry clearance applications, as new policy has still not been published following the existing policy found unlawful.
Okay, so I mean, because they still don't have the, I think you're talking about the challenge that was brought by by council at Doughty Street. I mean, unfortunately, it's a really poor system where there's no way to make an application because they simply don't have a process for entry clearance. What I'm hearing from those that instruct me is that the way that they're doing it is using the free family reunion application, and explaining that despite that fee waiver request issue having been found to be unlawful, nothing has been put in place. So this is the only way that they can still submit an application without having to pay huge fees. Adam?
Yeah, no, I was just looking up at what the guidance says on my iPad. So it says this currently, and I think the person who wrote the question may be aware of this, but just for everybody else, the guidance for the discretion to waive a fee in other cases is being revised. It is not currently operational. You can still apply for a fee waiver, but your application will be put on hold pending the revised guidance. So it seems the guidance is not out at the moment. I can certainly see, you know, a benefit in using the family reunion as a way through it. What troubles me is you may be stuck on hold. So if there's a way in an entry clearance case through family or people in the UK to get the fee, it would be worth making the application with the fee, because you've got that balance then with being stuck with the application on hold for some time. But yeah, I can't take it any further than that. Okay,
thank you. So one of my clients received a positive conclusive grounds decision, but SCA refused DL on basis that he did not wish to pursue the police complaint due to his fear. Asylum claim pending. I believe that the SCA's decision is unreasonable. Is it worth requesting recon of the DL?
So I don't know how long ago they refused to grant DL, but because his asylum claim is pending and the Court of Appeal have held that in that client's situation, he should be granted discretionary leave to remain, what I would have done is challenge the refusal of discretionary leave by way of pre-action letter and said that have a look at KTT, and that shows that your decision making is plainly wrong. And of course, if they then came back and just maintained their decision, then you would move to judicial review. Now, if you're out of time to do that, then what I would suggest you do is that you write and seek DL, relying on the Court of Appeal decision in KTT. And you can highlight that you're aware that they're appealing that to the Supreme Court, but say regardless of that, right now, this is the law and your client shouldn't have to wait any longer for a grant of discretionary leave, particularly because they're in such an early stage with their appeal to the Supreme Court. Adam, would you agree
Yeah,
with
no,
that?
I think that's right. You may have grounds to challenge their actual stated reasons for not granting
Yes.
DL. Have a look at the policy in relation to, not pursuing the police complaint aspect. But I think because of KTT, it may be worth doing what Priya said as the sort of second option, is writing and saying, well, notwithstanding your reasons for not granting, we've now got an outstanding asylum claim following KTT. We should be granted. And yeah, so I think even if you can't challenge the actual stated reasons for not granting DL, or if you're out of time, you've now got a new basis upon which you should be granted, namely the outstanding asylum claim.
Okay, thank you. So one for Adam here. Can I call a witness in Pakistan to give evidence in an appeal over video link?
You can have a go, but you can have a go, but you might not get anywhere. Yeah, I'm not dealing with cases certified under Section 94B, and Priya may have some more to say about that later in relation to her case of Yilmaz. But obviously, in my webinar, I talked about the Agbabakia case, and forgive me if I mispronounced that, where we got the guidance revising the NARE guidance. But since then, we've had the presidential guidance note number 1 of 2022. And very much that seems to be anti people giving evidence by video link. So it's very much saying, well, it's a matter for judicial discretion. If you want to call somebody by video link, first you've got to say why you want to call them and what they're being called to establish. So you've got to sort of let the tribunal know. The respondent's given a period of time to respond and to say if that's in dispute. And if it's not in dispute, you'll just be told to rely on the documentary evidence. If it is in dispute, then you'd need to sort of apply to the taking of evidence unit in the Foreign Office. And even if you do get permission, if there's going to be delays and the like, the tribunal could still rule, well, and this is the sort of direction of travel, well, we don't need actually oral evidence, we can just rely on a witness statement. The one thing there is traditionally witness statements from appellants in entry clearance cases haven't been given much weight. But I suppose if they've not let you give evidence by video and you've asked to do that, they'd have difficulty then giving it little weight just for the reason that he or she hasn't appeared before the tribunal. But there's very much a sense in this presidential guidance is they're anti the giving evidence over video link, and that's very much the flavour of it. So even though the case law relaxed the NARE requirements, I think because of concerns of delay in the tribunal getting clogged up, this presidential guidance has gone that way. I don't know if that's your experience as well, Priya, in terms of any of these requests.
Yes, I mean, the case of Yilmaz is an interesting one because it's a Section 94B case, so it means that the Secretary of State has removed that individual pursuant to deportation, and actually they have to set up that individual being able to give evidence from abroad. So that means they need to ensure that they're seeking permission from a foreign state. And what actually materialized in Yilmaz is that their method of doing that was writing to the state and seeking permission, or indeed letting them know that this was happening, but taking it that if they didn't receive a response, that meant that there was no objection by the state to the individual giving evidence. Now, it's clear from the case that Adam mentioned, Agbabakia, that wouldn't be okay. There needs to be actual permission from a foreign state before oral evidence can be taken by a court or tribunal in the UK. And what actually happened in the case of Yilmaz and Armin is that once they finally heard from the Turkish authorities, which was years later, when they had made a second request, the Turkish authorities were not willing to give permission, so they had to bring those individuals back to the UK. Well, they brought one individual back, the other unfortunately can't be found, so that they were able to give evidence at their appeal hearing. So it's clearly going to create some tricky issues in their Section 94B process if they try to revive that again, because it's at least clear that one country, and probably more, are not going to agree to individuals giving evidence from abroad, but certainly where we wish to ask appellants or witnesses to give evidence from abroad, we need to make sure that we are following Agba Biarca.
I think if you can't do it, or if permission is not going to be given, there is possibly, I suppose, the option of getting a direction that both sides put questions and they're dealt with in writing. Perhaps, I don't know whether a client, I'm thinking out loud, you could give a video response to questions, but I suppose the recording of an answer to questions put may be a possibility. That doesn't stop an appellant observing their own hearing, but obviously just linking that with the question we answered earlier about in-person or video hearings, where we're moving now back to in-person. I'm not sure if the tribunal will set up like a hybrid hearing just so the appellant can dial in to watch an in-person hearing with his partner giving evidence, for example. So it'll be interesting in relation to that, but it's a bit of a negative one in terms of I think we thought that the NARA had been relaxed and in more cases we'd be able to, although what I always say is do consider whether you actually want your appellant giving evidence from abroad, because often in entry clearance cases, they're the worst people in.
Not necessary, is it?
You want the nice, sweet, innocent sponsor giving evidence, and not that idiot of a husband of hers who's previously overstayed and got in trouble. So just have a think tactically as well.
Okay, thank you. So the next question. One of our clients has a business in the UK. She is paying taxes, but she has been refused EUSS pre-settled status. The admin review has been submitted in October and still we cannot know anything about it. Is this a reasonable grounds for a late application? She needs to come to the UK to take care of the business.
Can you repeat the question?
Sure. One of our clients has a business in the UK. She is paying taxes, but she has been refused EUSS pre-settled status. The admin review has been submitted in October and still we cannot know anything about it. Is this a reasonable ground for a late application? She needs to come to the UK to take care of the business.
So it sounds like she's out of the UK at the moment, but a business in the UK, and she's been refused pre-settled, but only given.
But we don't know the basis on which she's applied.
No, I suppose there's potential. One thing that jumped in my mind was potential to do a pre-action protocol letter, just challenging the delay on the pre-settled status, because is it seven or so months now since that? So in terms of, without us knowing the particular reasons for the refusal of pre-settled status, certainly there's a basis for delay. In terms of the second part, because it says, is this a reasonable ground for a late application? Well, if there's a pending pre-settled status refusal admin review, that would, or is the questioner thinking, do I make another application? Possibly. And so you say, well, we're making another application late because we're still waiting on the admin review. Whether you get a different outcome than the refusal that has led to the admin review, I don't know. Whilst we haven't looked at the new sort of business routes in the new statement of changes, if she's got a business in the UK, perhaps look into that and see if there's any scope in relation to any of those routes.
Okay, thank you. So this question for Priya. I saw the recent decision in AS versus Secretary of State for the Home Department 2022, CSIH 16, regarding Home Office duties to provide information to establish a child's nationality. Could you summarise that decision and your views on it, please?
Sure. So it's a Scottish Court of Session decision. It's quite a disappointing decision. Now, in that case, there was a mother who wanted to try to establish the nationality of her child. She said that the father was German, but that he also had permanent residence in the UK. So that meant that the child was British, because when the child was born, the father was settled. And she didn't have any contact with the father of the child, and she wasn't able to obtain any documentation to try to demonstrate the father's nationality. And she sought a direction initially from the first tier tribunal that the Home Office confirm the father's nationality, but the tribunal said no to that. And so there was an appeal to the upper tribunal, and there again, she sought a direction. Before she, when she sought a direction, the upper tribunal again didn't grant that, but they also would not look at evidence that she tried to submit to at the upper tribunal to prove the father's nationality. So the case was appealed to the Court of Session, and they said that there isn't an obligation on the Home Office to prove the father's nationality. There needs to be reasonable steps taken by the applicant to try to establish the child's nationality. So that might mean approaching embassies. They have to exhaust all possible avenues. Now, in that case, actually, there had been an approach to the embassy, and what had happened was that they, of course, were unwilling to assist because of data protection issues. Ultimately, the mother was really stuck. But whilst they said that the Home Office were not obliged to assist, they did say that the tribunal had to make a finding on nationality, and that they shouldn't have just not taken into account the evidence that the mother wished to submit in support of the child's nationality. So the appeal was successful on that basis, and indeed on another basis that related to asylum grounds, and there will have to be a finding made by the tribunal on the basis of the evidence that is available on that child's nationality. But my view is that it's quite a disappointing decision, because it probably wouldn't take very much for the Home Office to check their records to be able to see what the father's nationality is. Adam, I don't know if you have anything to
not
add
really.
to
It's one of those difficult issues, isn't it? Proving a parent's nationality. You get the sense the Home Office will always jump to hide behind data protection, and you're not surprised that the sort of attitude of the courts, but it's one of those to try and get as much evidence as possible then, and as you say, force the tribunal to make a finding.
Okay, thank you. On the subject of pre-action on delay of EUSS admin reviews, what is the High Court's stance on these delay matters?
I think, well, I think I'm about to be instructed on one, but I haven't had one go through yet. One is concerned about delay JRs at the moment in the light of COVID. I think with COVID and Ukraine going on, you've got the Home Office that are behind because of COVID and now diverting a lot of resources to Ukraine. So I get the feeling at the moment, delay JRs, the Home Office may be given a lot of latitude. But with the settlement scheme and admin reviews, they are supposed to be dealing with this in a much more prompt, streamlined manner. So I think the normal principles would apply. And I still would think after a certain length of time, and responded pre-action protocol letters, and if they refuse to give a timeline as to why, then it is worth pushing for judicial review if your clients can afford it, knowing the cost risk. But I just, the hesitancy I have is because with all that's going on, will latitude be given to the Home Office? And the courts are often give them a lot of latitude with delay generally. If you can show particular prejudice, maybe effects on children and those kind of thing, a particular prejudice with the delay, that might help. I don't know, Priya, if you've got any views on that.
Yes, I was just going to say that, Adam. You need to try and demonstrate particular detriment so that the court are likely to be more interested. And the way to show particular detriment would be, there might be somebody who's really anxious, who it might be causing issues in their family life. They might have a relative abroad who's very unwell that they're unable to go and see as a result of all of this. So if you can demonstrate that through evidence, and you can show that you have sent that evidence to the Home Office, and you have written to them repeatedly to say, what's going on, and you've not received responses to letters, then that's going to help you in arguing that it's unlawful delay. If you have a look at the cases on unlawful delay, they talk about how bad administration by the Home Office can often strengthen an applicant's case in this regard. So write to them repeatedly. You really need to set up a case on delay really well. It can't simply be sending one pre-action letter and then going to JR. I think the court will probably think that you have acted too quickly. You need to give the Home Office an opportunity to respond and explain. And I often advise in these cases that it's useful to get a subject access request so that you can see whether the Home Office have actually been doing anything. Because if that shows that there's been 7 months where they've just received the application and they've just sat on it, then that's really going to assist you. Or it might even show that they have had 7 months of the application having been sent in and then repeated letters saying, you know, what's the progress, what's happening now, and no response, then that's going to assist you too.
Yeah, I think that laying the foundation is so important with evidence. I think that yeah, if you can, before you get to the pre-action protocol, as Priya said, send that letter with the evidence. I think that does must up your chances of success, definitely.
Okay, thank you. So it's a really long question next, guys. We have a client who was born in Aden and is a Somalian national. He came to the UK 15 years ago on a visit visa and has many unsuccessful applications for asylum, FLR, statelessness. Our application for a British overseas passport was recently accepted and he was issued the passport. The problem is this does not provide a right of abode. What would be the correct application to get the right of abode or to reside? Applying for a British passport does not seem appropriate because he was not here legally for 5 years.
I wonder if that's a bit of a specific question to answer on this. I know it's a Somaliland national, so just a thought off the top of my head is perhaps the first thing to do is try and get some leave remain first, on the basis that he can't go anywhere. There is cases where somebody's not removable, and sort of the like limbo cases where they get to a point in limbo where somebody should be granted leave to remain, because I don't think you're going to get straight to a right to abode. But that is a very specific question that even if that came from me for advice, I'd be scratching my head and taking a good few hours over. I don't know.
I would too. I think that one needs to be looked at. And of course, as I said earlier, you know, it's open to whoever that question has come from to contact me or Adam after this session with the actual document so that we could properly advise on that sort of question.
Okay, thank you. So next question. My asylum cases are significantly delayed by the Home Office. Do you think a JR pre-action can be appropriate in circumstances that clients are also not given permission to work?
I mean, I'll start on that and Adam add to it. So as we said about delay in EUSS cases, you need to set up a delay challenge by writing to the Home Office in advance of a pre-action letter. So you need to be able to say to them what detriment is being caused to your applicant. And it may well be that not having permission to work is part of what you raise. And you might be able to refer to correspondence where you've asked for that and they've refused it. And it may well be that your client is saying to you, you know, I'm feeling really hopeless, really isolated, really anxious, really depressed at not having anything to do in my day-to-day life and simply having this hanging over me. If that's what you have, then I would suggest a witness statement in which you explain all of that, or indeed medical records that demonstrate that that's what your client is experiencing, and you send that to the Home Office in a letter and say, you know, reconsider the permission to work, or give us a short timescale for a decision, or explain why there is delay. Again, also make a subject access request. You may well not get a response to that, or you might get an unsatisfactory response, in which case you might want to write again or move to a pre-action letter at that stage. And then after that, you would be thinking about judicial review. But as was said previously, you really need to set it up well.
Yeah, I think there's those two. You've got two interlinking issues in this question. You've got the delay in the outstanding asylum claim, and that's all the stuff that Priya and I have talked about setting it up with the detriment. Then you've got separate issues of permission to work and making an application if there's been no decision on the claim within the initial 12 months and it's not the fault of the claimant, making that application for permission to work, which in and of itself may be challengeable on separate grounds. It's separating those two things out, and they're showing the prejudice for the ongoing delay within the asylum claim, bearing in mind what I said about COVID, and perhaps there'd be a bit more sort of generosity in relation to the Home Office in terms of delay, and then the issue about applying for permission to work.
Okay, thank you. So we submitted an application for settled status on 24th of December 2020. On the 17th of April 2021, we got a voicemail from the Home Office. We are going to grant settled status as we have confirmed his marriage and residency. You should receive an email from us shortly. No further communication was received. On contacting the Home Office, we are informed it is still under consideration. Do you think we should send pre-action letter to start JR?
Adam, have you ever heard of a voicemail?
No, no, that is really bizarre, isn't it? That I suppose the settlement team, the EUSS team, are more used to contacting reps, and there is that culture of getting in touch with reps. The difficulty is, and again, like Priya said earlier about getting a subject access, I think I definitely want a subject access on this because it should be recorded. The only difficulty is that might take a length of time to get it. What it might be worth doing is doing a sort of, again, like we've said in a lot of these delay issues, setting up the groundwork by setting a letter, perhaps even with a witness statement from yourself saying, on this date, I don't know if you've got the recording of it still, you know, you could transcribe it, or, you know, I got this voicemail. So whether this, because you would have thought if it was just pending security checks or anything, that should be done by now. But whether it was a caseworker gone rogue, who knows? But I think it's potentially worth pre-actioning them, but with, or maybe first, as we've said, with a letter setting out the basis and maybe a witness statement or subject access if you can get that in time.
Okay, thank you. So a question for Adam. Where are the Home Office Ukraine concessions now found?
Yeah, that's helpful actually, because when I recorded my webinar, they were still sort of policies by the Secretary of State. We've now seen a change to the immigration rules, and there'd be a specific appendix. So it's now within the immigration rules, and it's called Appendix Ukraine Scheme. So within the Appendix Ukraine Scheme, you've got the three routes. You've got the Ukraine Family Scheme, the Ukraine Sponsorship Scheme, and the Ukraine Extension Scheme. The Ukraine Extension Scheme are for those already in the UK with permission, or permission that ended after a certain date. That's not open yet. That'll open on the 3rd of May 2022. But in terms of the Homes for Ukraine Sponsorship Scheme and the Ukraine Family Scheme, that is now within the Appendix Ukraine Scheme. And it's part of the government's simplification of the immigration rules that we're seeing these appendices replacing the sort of substance of the immigration rules. But with the recent big changes, there are so many appendices now to the immigration rules. So have a look. But that is now one of them. The Ukraine scheme has its own appendix in the immigration rules.
Thank you. Is there any chance for an asylum seeker to work waiting for the appeal decision? There was no delay, but the case is going on for years now. Is it worth to try to write to the caseworker?
So there's actually an immigration rule under which you can apply for permission to work for an asylum seeker. It's paragraph 360 of the immigration rules. And what it effectively says is that somebody can apply for permission to work if a decision hasn't been taken on their asylum claim within a year on the date that the claim was first made. And there can't be any delay that's attributable to the actual applicant. It's delay really that's just caused by the Home Office and their administration. Now the rules are far more detailed than that, but that's your starting point, and the answer is yes, there is a chance that that individual would be able to seek permission to work.
Adam, do
you want to add to that?
Yeah, no, there was that bit. It seems to be where it said there was no delay. I suppose, I don't know if they mean the cases going on in terms of ongoing appeals. One thing I would say is if obviously those rules and the rule that Priya read to you, 360, is specific to delay, where you fall outside of those rules, you may be able to have a look at the policy and invite them to use discretion on particular circumstances. You may have a very difficult task if you don't fit within the rules, but there has been successful challenges over recent years, say, where the rule requires you to be granted work under the shortage occupation list, and they have got, the court said, well, no, there is a discretion not to apply the shortage occupation list to that. So if there's a particular detriment and you can show why they should be granted, you could apply on a discretionary basis, but the first and the primary approach will be that within the rules.
Okay, thank you. So one for Priya. I have a sham marriage hearing coming up and have come across the decision of the tribunal in Saeed, deception knowledge, marriage of convenience, 2022, UK UT 18 IAC. Impact, if any, will that have?
Okay, so I mean, Saeed doesn't say anything new. What it does is it reminds us that there's a difference between the definitions of sham marriage and marriage convenience. So a sham marriage is defined under the Immigration Acts as one where there is no genuine relationship between the parties to the marriage or civil partnership, and one or both of the parties enter into the marriage for the purpose of circumventing UK immigration control. So that you can see there's two parts to that. First, there's no genuine relationship, and second, they're entering into it for the purpose of circumventing immigration control. A marriage of convenience is defined as one entered into for the purpose of circumventing immigration laws. So what that means is that you can have a genuine relationship, but if the couple are marrying to circumvent immigration laws, then that means it's a marriage of convenience. Now, you need to be quite careful about Saeed, because in Saeed, they rely on a case called Molina. And it doesn't appear that counsel or the Home Office representative or indeed the judge was aware that the High Court decision in Molina was actually appealed to the Court of Appeal, and it's settled by consent with a statement of reasons. And that statement of reasons basically said that the Home Office accepted that there was a genuine relationship between the couple in that case, and that it was wrong for them to conclude that it was a marriage of convenience on the particular facts of the case. So if you have reference to Saeed by the Home Office, then make sure you refer the judge to the fact that Molina has been successfully appealed to the Court of Appeal, and the statement of reasons in Molina is available online on the Free Movement website.
Thank you. So the last question to Adam. Do bookended periods of overstaying count towards 10 years long residence?
Well, I hope everybody's still awake at the end of this session, because now we're talking about bookended and open-ended overstaying, and these sort of issues have led to a lot of head scratching over recent years. So those who are regular practitioners listening today will know about the case of Hock, where Lord Justice Underhill distinguished between open-ended periods of overstaying, and you can't build up your 10 years relying on those open-ended. So if you're trying to rely on 39E, making a late application to get to 10 years, you can't rely on those. But he did talk about overlooking these book-ended periods. So those are the ones provided by 276B Roman 5, the 28 days or the 14 days, depending on which provision you were under. Now, we all thought after hoc you could count those bookended periods as positively going towards your 10 years. And in fact, there was an upper tribunal case by Upper Tribunal Judge Blum called Manib Asif that said the same and rejected the Home Office argument. But in a recent case, and it's a really heavy-going case, a case called Afzal, which I look at in my webinar. So I'd encourage you to go back to our 4 webinars that we've recorded that form the basis of today's session. But in Afzal, the Court of Appeal take a different view and say, no, that was obiter. Whilst bookended periods do not break the continuity of residence, you can't count them positively towards the 10 years. So, you know, it basically stops the clock, but it doesn't reset the clock. So that's the current thinking. Afzal said some really interesting things. There's some interesting approach to 39E and invalid applications. And I'm not sure it's the end of the story on all of this, but certainly for your purposes, following Afzal, you can't positively use those bookended periods to add up to the 10 years.
Okay, thank you. So unfortunately, that's all we have time for today. Thank you for attending Law 2022 Online Immigration Law Shape the Debate, sponsored by Trinity College London. Thank you to our expert speakers, Adam Pipe and Priya Solanki. Don't forget to join the solicitors group Law 2022 Online community on LinkedIn to continue the debate after the live session and to be included in the exclusive offers for next time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. Feedback form for the event is found in the related links section of the online course, and after submitting this, you will receive your CPD certificate via email. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from our webinar learning catalogue. You can also visit our exhibitor profile for more information on Trinity College London. I will stay on for a couple of minutes just in case there are any questions or if you would like any further information, contact details, etc. Thank you again and have a great day.
Thanks, everyone.
Thank you.
Thank you.